Do you own a business that you're thinking about selling? Or maybe you want to buy a business instead of starting one from scratch? We're going to talk about the ins and outs of buying and selling small businesses in the first of this 6-part series, coming up right now. My name's Matt Crumpton. I am an attorney by trade. I was the CEO of the DPDO restaurant franchise, and right now I'm the CEO of the Big Mama's Burritos restaurant franchise. So I've got, the experience of wearing both the CEO hat and the attorney hat, and there are definitely different considerations to have there. One of the benefits of, having that experience as an attorney is that it's been pretty easy for me to buy and sell businesses. And that's kind of how I got started in restaurants, was just, doing small deals for clients. And then I thought, hey, that sounds like something I'd like to do. So I've done dozens of asset purchase agreements throughout my time since I've been an attorney. And what I'm going to do in this series is just share with you how I think about and how I approach buying and selling businesses. And by the way, I'm just going to talk about asset purchase agreements. It is possible to buy and sell businesses through other ways. You can buy or sell a business through a merger. You can buy or sell a business through buying shares of stock or membership units in an LLC. But what I'm going to talk about is an asset purchase agreement, which is where you're just going to buy the assets and not take the liabilities of the business. When you buy shares, you are going to have the liabilities as well. There are reasons to do that for some transactions. The main reasons, by the way, that you would ever want to do a deal where you buy shares as opposed to assets, where you're buying the entity itself and keeping the same entity, is that there's no liabilities, and from an administrative standpoint, you would rather just not have to set everything up all over again, pay all the deposits, all that kind of stuff. And if your landlord will not allow you to transfer to a new entity, that's another reason. They could just transfer shares. By the way, there may be a provision that still requires the landlord's approval, but wow, we just went down a little rabbit hole. But I'm just trying to tell you guys, what I've learned and share it all with you. So let's talk about the roadmap for how we're going to approach buying and selling businesses as we talk about it in this series. There are 5 key steps. Here they are. Number 1, letters of intent. So a letter of intent is a formal offer where the parties agree upon the material terms, things like price, all those fun things, and they also have a lot of contingencies. So things have to come true later for the deal to be binding. And one of the big contingencies is usually they have to mutually agree on a long form agreement. So they may have, you agree on the price and you agree on what you're buying and selling, but you don't agree on all these other tangential terms that turns out were material to both sides, but it wasn't in the LOI. And so that's why LOIs are not fully binding yet. They're just the main points, but you kind of hammer the sides down on, or rather you secure the main points of the deal so that you can talk about other parts of the deal. The second big part of asset purchase agreements are negotiations, and really negotiations go hand in hand with the LOI. The LOI is typically the device used in the negotiations over those key terms. So I'm going to go into strategy on negotiation, which, full disclosure, this is not law. It's a little bit more like voodoo combined with just sort of psychology. But I'll just share with you my perspective on negotiations without literally giving away everything, because guess what? I still have some negotiating to do. Number 3 is the asset purchase agreement itself, or the long form asset purchase agreement. And like I was saying with regard to the LOI, the asset purchase agreement keeps those material key terms from the LOI, but then it adds in all of the process. So, the price and the assets might take up half a page in the LOI or a quarter of a page. And all the details for that may take up 4 pages in the long form agreement. If there's an agreement on the material terms, usually the parties do end up reaching an agreement on the tangential terms. But that's why if you ever think that you have, there's something for you that's really important to you in a deal that isn't typically important to other people, maybe, not to say that it shouldn't be important, maybe it's just not, right? But if that's the case, you should put that specific term in the LOI, is my opinion, just to go ahead and make that clear up front so that they don't try to change it later. Fourth big part of asset purchase agreements is due diligence. Okay, so from a process standpoint, here's the timeline. You have the negotiations and with the LOIs that go back and forth. Finally there's an LOI that's accepted, it's signed by both sides. Okay, those terms are locked in. The next thing is you negotiate the long form agreement. The lawyers go back and forth. It usually takes at least a few weeks depending on how engaged your lawyers are and how many other things they have going on. But the next thing after that, once you have the long form agreement, you have a due diligence review period within that long form agreement. And that's a negotiable thing, but make sure you give yourself enough time to cover all the ground you need to cover. So we're going to go in depth on due diligence. And then at the end of the due diligence review period is the closing, and that's when you formally take over the business. And then that brings me to point 5, which is the post-closing, post-closing transactions and just issues related to the transition of the business. So those are the 5 key steps. But before we even reach that, let's first just talk about the first thing you need to do, which is a business plan, right? Figuring out where are you trying to go, what are you trying to do, what are your goals? And really in terms of so there's what are your business goals? That's a whole conversation about having a business plan, okay? And then from a negotiation deal standpoint, the question is what are your deal goals? So if you're the seller, what is your range that is acceptable to you? If you're the buyer, what's your range? Because in deals, this is what I love about deals as opposed to litigation. You can get a win-win. In litigation, it's not win. If you win, congratulations, you have a ton of attorney's fees and they might appeal it. And you didn't even get everything you wanted. Good job, it's awesome, yay. However, in the transactional game, in the world of deals, it's all about win-wins, okay? So a deal is born, it happens, when the buyer's win-win window overlaps with the seller's win-win window, which is just another way to say everybody's got an acceptable range and you want to thread the needle on the point that's best for you, and it's still acceptable to the other side, but you're maxing out your opportunity. So that's the whole negotiation game. But it's still a win-win, okay, if they take the deal. So that's the nature of negotiating. But for you to be able to do that, you have to know what are you trying to get, what are your goals. So this is a conversation about financing offers and seller financing. It's a conversation about interest rates and what should the purchase price be and what monthly payments can you afford, which goes back to having that business plan, having a pro forma so that you have worked in the loan payments for any financing and can I afford this or not. So speaking of business planning, one tool that I enthusiastically recommend, you can talk to anybody who knows me, I talk about it all the time like I'm real enthusiastic, okay? But it's called the Traction Entrepreneurial Operating System, the Traction EOS. It's based on the book Traction by Gino Wickman, and I'm not paid for Traction, and by the way, I don't pay them for the right to use their trademarks or to be a coach. I'm just saying I love it and it's amazing. So read the book. Basically, here's what it is in a nutshell. It is a 2-page business plan method where you've got a page that covers your vision for the future, and you have a 10-year goal, and then so you ask yourself, what is the 10-year picture that I'm looking for? What am I trying to do here? And you then zoom out to a 5-year goal. So what needs to be true in 5 years for me to hit my 10-year goal? Then you ask yourself, what needs to be true in 1 year to hit my 5-year goal? And then you break it down into quarterly projects, which are called rocks. You have recurring quarterly planning meetings, and you have recurring weekly meetings where you address issues, fires, and you also cover your rocks that were assigned so that you make sure that you're actively executing your business plan every week. One other tip before we dive into letters of intent and get granular on the whole deal process. If you've never bought a business before or sold a business and you're kind of wondering about pricing and terms and all that kind of stuff, I would take a look at BizBuySell.com. It is a great website for a lot of small businesses, and you can just kind of see what things are going for. You can see the low end of the spectrum, the high end, what are the differentiators that seem to exist there. They don't usually give you cash flow numbers, but they do always give you price numbers, and some of them will say whether they have seller financing or not. So just something to consider if you are new to the game of buying and selling businesses. Let me know if there are any questions you have off the bat in the comments, and I will make sure to address them as I get to the relevant topic that covers whatever your question is. Thanks a lot, and we will see you soon with the next installment.